Good evening, everyone. YouTube Nation. We're finishing off here on the Executors and Administrator Guide, starting off 40. If we continue the series, I'm gonna try to have an attempt to read this whole 450 pages. And I will have some PDFs at the end so you can execute your own uh, Will Testament letter. Okay, so to bear with me, this is something where you can just go over time and master this task. So I'm gonna go right on in. Page 40. Person but shall be liable and administrator for the debt of his wife only to the extent of the asset received by him. In the case of person not an inhabitant of this state dying and leaving assets in this state, administration shall be granted, first to relatives applying, and in case such do not apply, then in the city of New York, second to the public administrators in all other counties, second to some person who may have been legally appointed administrator in any other state, who, on producing his letter granted in such other state, shall be entitled in preference to creditors, or to some person appointed by the foreign administrator to receive them. But if none of the persons above specified apply, then creditors or other proper person may do so, and after the proper citation may receive letters. And any person entitled to letters by filing his or her consent in writing may have a competent person, not otherwise entitled, join in administration 2R.S.75, abbreviation 3R.S. 5th edition 160. As for example, a widow may have her father or brother or another person join with her. A son or daughter may have any competent person join with him or her. The consent requires may be embodied in the petition. When this consent shall have been acted on, 41, and letters issued, the consent cannot be revoked. A state of Elijah D. Williams, 1 Tucker, 8, where a married woman is entitled to letters, the same may be granted to her as if she were unmarried. Chapter 782, Laws of 1867. And if any person who would otherwise be entitled be a minor, such letters shall be granted to his guardian, the same as they would be to the person so entitled if of full age. 2R.S.75, 3R.S. 5th edition 160. 32, page 75, 3R.S. 5th edition 159. No letters of administration shall be granted to any person convicted of an infamous crime, nor to anyone incapable by law of making a contract, nor to a person not a citizen of the United States, unless such person reside within the state, nor to anyone who is under 21 years of age, nor to anyone who shall be judged incompetent by the surrogate to execute the duties of such trust by reason of drunkenness, improvidence, or want of understanding. The surrogate cannot exclude a person otherwise entitled to letters except for that cause specified in the statute. Coop versus Laurie, 1 Brav, chapter 45. As the degree of drunkenness and incapacitating an applicant, see Elmer versus Kalaki, Redfield, 472. 42. 5.L.S. 1867, chapter 782. Any surrogate may, in his discretion, refuse the application for letters testamentary or letters of administration of any person unable to read and write the English language. But before the issuing of letters, the applicant must produce a file with the surrogate reunification executed in a manner heretofore prescribed in speaking of citation by executors. See form appendix. All persons having a prior right to administration, or the surrogate must issue a citation to such person, requiring then to show cause why administration should not be granted to such applicant. One who has renounced may revoke his renunciation at any time before letters are actually granted. Casey versus Gardner 4 Braid 13. The citation must be served on such a reside in the county personally or by leaving a copy at their residence at least 6 days before the returning day thereof, or such reside in any other county in this state in the same manner at least 40 days before the return day, and on such reside of out of state whose residence cannot be ascertained personally at least 40 days before it return, or it may be published, as against those out of the state, or whose residence cannot be ascertained once a week for 6 weeks in the state paper. 43. In all cases of publication, a copy must be mailed to those whose residence can be ascertained at least 30 days before the return date of the citation. A like citation must be served at least 20 days before it return on the Attorney General of the state in all cases where it does not appear in application, or other written proof to the surrogate that the interstate left kindred entitled to his estate, specifying names of residents as far as can be ascertained. See petition order in appendix. On the application thereof, therefore, if the person applying has the first right or is one several equally entitled as a class, or a filing of the renewed citation in person having the prior right, or on the return day of the citation to such person, if they or some of them do not take letters or show cause why the applicant should not have them, letters will issue to the applicant on his taking on oath an affirmation before any officer authorized to administer the oath, and filing the same with the bond required. See oath in appendix. The bond is executed to the people of the state with two or more sureties to be approved by the surrogate, and in a penalty of not less than twice the value of the personal estate of which the deceased died possessed. 44. The surrogate may examine such person as he may think proper as to the value of the personal estate, and he may also require the sureties to justify execution of the bond must, in all cases, be acknowledged or approved before the surrogate or some person authorized to take acknowledgement of deeds. See from appendix. Special letters of administration may issue in the discretion of the surrogate when in the case of the contest relative to the proof of a will, or relative to granting letters testamentary administration with the will annex, or administration in cease of intensity, I believe, or whereby reason of absence from this state of any executor name in the will, or for any other cause, a delay is necessary produced in granting such letters. Before taking such letters, the person appointed collector shall take the oath of office, and shall give a bond with sureties the same as the case of general administration. 2R.S.76, 3R.S. 5th edition 160. See appendix. See form in appendix. His duties when appointed extend only to the collection or preservation of the estate personally of the deceased, and he has authority to collect the goods, chattel, personal estate, and debts of the deceased, and to secure the same at such reasonable expenses as the surrogate shall allow. For these purposes, he may maintain action as administrator, and under the direction of the surrogate, he may sell such of the goods of the deceased as shall be deemed necessary for the preservation, and benefit of the estate, after the same shall have been appraised. The condition of the bond of such special administrator, who is also called a collector, is that he will make a true and perfect inventory of such of the assets of the deceased as shall come into his possession or knowledge, and return the same within 3 months to the office of the surrogate, granting the letters that he will faithfully and truly account for all property, money, and things in action received by him as such collector, whenever required by the said circuit or any other court of competent authority, and will faithfully deliver up the same as the person who shall be appointed as executors and administrators of the deceased, or such other person as shall be authorized by the circuit to receive the same. It has been held that the sureties of the special administrators are liable for money received by him before his appointment. 19 New York 150.